I'll say a quick word on derogability. As we noticed, one difference between the two bodies of law is that many human rights can be subject to derogation in times of public emergency. Humanitarian law, because it applies specifically to situations of emergency, there can be no derogation from. But it's worth noting that even where derogations under human rights law are permissible, they are so only to the extent strictly required by the situation on the ground, and only provided such measures are not inconsistent with the state's other obligations under international law, and they must also not take place in a discriminatory manner. So one can argue that the existence of derogability means that human rights can be suspended in time. One cannot argue that the existence of derogability means that human rights can be suspended in time of conflict. Rather, the existence of derogability is framed in such a way as to permit the suspension of certain rights, but only following a specific regimen. And implicit in this regimen is the idea that the suspension cannot lead to the undermining of other international commitments, for example, international humanitarian law. Another difference between the two bodies, of course, is that human rights law is monitored much more rigorously than humanitarian law by a structure of treaty bodies and intergovernmental mechanisms. So much more jurisprudence is developed in the human rights sphere than in the humanitarian. The Human Rights Committee, which is tasked with oversight of compliance with the International Covenant on Civil and Political Rights. Indonesia is due to report to that body soon, by the way. Has applied then treaties that its treaty continues to apply in situations of armed conflict, including situations of occupation. And the same is true with those committees that supervise compliance with the Convention on the Elimination of Racial Discrimination, of discrimination against women, on the rights of the child, and so on. And the International Court of Justice, supreme arbiter on these matters, has stated explicitly in its advisory opinion on the use of nuclear weapons that the court observes that the protection of the International Covenant on Civil and Political Rights does not cease in time of war, okay, except by operation of Article 4, which deals with the situations of derogation. And it goes on to note that the right to life is just such a provision which may not be subject to derogation. Again, following that, in its advisory opinion on the wall in the occupied territory, the ICJ reaffirmed that human rights law continues to apply in situations of conflict, and it has done in a number of other cases since then. One interesting aspect to think about here, and which is very relevant in situations of occupation and also in situations of some of the ways in which the war on terror has been conducted, is the extraterritorial application of human rights law. Because of course human rights law focuses on a state's commitments and obligations to those individuals within its jurisdictions. War, of course, often takes place outside of the state's boundaries, begging the question of, does the state's obligations also extend beyond those boundaries in a situation of war? The ICJ, the International Court of Justice, is clear that human rights law, in respect of acts carried out by a state, does continue to apply in respect of acts carried out by a state outside its own territory, and particularly in occupied territories. The key issue, they said, was to consider the degree of effective control of the territory of the individuals in question. So in other words, if a state does have effective control, then human rights obligations follow with it. And this indeed was also, this discussion of effective control was also the position adopted by the Human Rights Committee in its general comment 31 on the International Covenant on Civil and Political Rights. And that committee has consistently applied this position to situations of military occupation and also to peacekeeping operations. So UN troops in the field will be subject to human rights obligations. Israel, the UK and the US have sought to contest this view, but they are minority voices. Moving now to look in a little more detail at some of the areas of interaction between these two bodies of law. We've accepted that human rights law can apply in situations of conflict. That still leaves open the question, which is a big one, of the nature of its relationship with humanitarian law, which by definition also applies in the same situation. In the case of the war in the occupied territories, the ICJ observed, and this is a quote, that some rights may be exclusively matters of international humanitarian law, others may be exclusively matters of human rights law, yet others may be matters of both of these branches of law. So an instance of the former, exclusively international humanitarian law, would include discussing the rights of prisoners of war. Rights which remain within the sole purview of human rights law would be those concerning freedom of expression and assembly, for example. And rights where both bodies of law might apply would be torture, ill treatment, right to life, and so on. I'm not going to go into a detailed discussion of the debates surrounding the precise nature of this relationship, because really we'll be here for all week and longer, but I will certainly prompt you to further reading for those who are interested. But in brief, I would say there are two differing interpretations as to how these laws interact. One adheres to the theory of international law called lex specialis, for those of you who study this. You can't give a lecture in law without mentioning some Latin at some point. So anyway, I've got my Latin out of the way. Which argues that in a situation of conflict, humanitarian law will inform the meaning of human rights. That the specific law trumps, in some ways, the general law.